Hi, this is Professor Higgins again, back in action. We're going to finish up lecture 10, and in this segment, we're going to look at the corporate management and how that is done by the directors and the officers as opposed to the shareholders that we just discussed in the previous lecture. So, we're going to jump in and get started on the requirements for becoming a director. A director is a natural person. It doesn't have to be a resident of Florida or even the United States, as long as they're a natural person over the age of 18. And really, those are the only requirements set out by Florida statute. The corporation itself can have additional requirements. Like many corporations will require that a director also be a shareholder in the corporation. That's pretty common. And then corporations can also have other requirements as they want to. It's really up to the corporation. Generally, directors have other real jobs, and so being the director on this corporation, sitting on this board, is not the way they make a living. They are there to guide the mission of the corporation and to help it keep its shareholders happy, make money, and to do whatever the goal of the corporation is. The number of directors, there has to at least be one, but that's determined by the articles or the bylaws, and they can say how many directors they want to have. Generally, it is an odd number. An odd number works best. A fairly small number, although there's no maximum. So you can have as many directors as you want. The authority of these directors. Now, directors manage the business of the corporation, and so their decisions or their decision-making power has to do with corporate operations. So they have the power to do the following: elect and remove the officers. They also fix compensation, such as salaries. They declare dividends, which is what the shareholders are wanting, always. They initiate changes for submission for shareholder vote. So if there's going to be something that needs to be changed and they need to get a shareholder vote on something, then they're the ones that kind of bring that up and make that happen. They are constantly inspecting the records to make sure everything is being operated correctly. They are reimbursed for their expenses, and the board of directors, each of the directors gets paid, which is kind of interesting because since they set compensation, they get to determine how much they think they should be paid. All right, number 6, they delegate authority to the officers and to committees. So if they set up, if there's something that's unique that's coming up that they need to examine, they might set up a financial committee to see if we have enough money to do X. They keep track of, and they kind of delegate stuff to the officers that they want done. They adopt bylaws. They amend bylaws. The directors have a lot of power that probably, well, I don't want to say the most power, but when they all agree on something and they want to get something done, it's easiest for them to make it happen. And then the directors issue stock. The role of the director can be expanded or it can be limited by the bylaws or the articles of incorporation. So it's really up to the corporation itself on how powerful they want their board to be, or how where they want to put the power. The election of the directors. There are initial directors that are named in the Articles of Incorporation. Then, when you have the articles of incorporation that are going to be read at that first organizational meeting, that's when those first directors are voted in. So those folks are very important. Then there are terms. There's generally a term limit. It has to be at least a year. But a lot of, let me just give you an example. A corporation might have 9 directors sitting on its board. And so after those first few years, they're up and running. Now we have directors who maybe this year, 3 of those 9 directors are going to rotate off the board and 3 new ones will come on. At the same time, there are 3 more directors that have a year left. And then there are 3 more directors that have 2 years left in their term. So every year you're going to have 3 directors rotating off and 3 directors being elected onto the board. That way you don't have a corporation where every single board member has fallen off the board or is rotating off, and so you have no experience and no corporate memory there on your board. Compensation of directors, here it is in number 5. The right to compensation is addressed by the bylaws. This is in chapter 607.0810 of Florida statute. Unless the articles of the bylaws state otherwise, directors may fix their own compensation. So that's a pretty good deal. Let's see. Meetings of directors. They can hold regular or special meetings, just like the shareholders, so long as the majority of the directors are present. Usually, the directors' meeting is called by the chairman of the board or by the president, who is one of the officers, unless the bylaws say differently. They can act without meeting at all if the board or particular committee consent in writing. And don't forget, even for the special meetings, you have to be notified pursuant to Chapter 607 in the Florida statutes, and you have to be given at least 2 days' notice, which specifies the time, the date, the place. Otherwise, they can sign a waiver, and you don't have to worry about that. Okay, so the directors now, when it comes to voting, unless the articles or bylaws say differently, a quorum is the majority. If you have a quorum of the directors, then you do have a majority, and the majority rules. So, whoops, shaking you around there. Sorry about that. The duties of the directors are as follows. The biggest one is the duty of good faith. There is a fiduciary duty that the director has on behalf of the shareholders. Now remember, in our last lecture we learned that the shareholders do not have a fiduciary duty to the corporation. However, the directors, all of the directors do. They also have a duty to act with care, the care of an ordinarily prudent person in like position would exercise under similar circumstances. This is a very low bar. This means that they don't have the duty to perform at a stellar level as a board director, as a director of a multinational company would perform. The only duty they have is to perform as a reasonable, ordinary person. So it's very low bar. Number 3, in a manner that board member reasonably believes to be in the best interest of the corporation. So you could have somebody that's a business buffoon as your director, and if they believe that they are doing what's best for the company, then as long as they weren't willfully doing anything criminally horrible, the court is going to support the board the director, because those directors have been elected by the shareholders. And if that's who the shareholders wanted, then the court's going to going to stand by that. The only time the court really takes a hard look at the directors is when they feel like there's been deceit or fraud. So when we start throwing those words around, or if we start hearing that, we know the court's going to get angry and get involved. Okay. Courts have also added a duty of loyalty. It's not a statutory duty, but it is a duty that the courts have put in our case law here in the state of Florida. So our directors have a duty of loyalty. Directors can rely on information obtained from reports or statements prepared by fellow directors, officers, employees, legal counsel, financial counsel, other experts to make their business decisions. Number 9, personal liability of the directors. Generally, directors cannot be held personally liable for damage caused to the corporation as a result of decisions made in good faith. There are circumstances, however, where a director may be personally liable. And if you look at chapter 0831 in our Florida statutes, we have a list of circumstances where you can be found personally liable. When the director fails to perform his duty as a director, if the director knowingly violates criminal law, if the director derives an improper personal benefit from a transaction, if a director acts in conscious disregard for the best interest of the corporation or with willful misconduct. Number 5, if a director acts recklessly or with wanton or willful disregard. This pretty much, you have to be an awful person. You have to be bad. You have to be doing bad stuff to be personally liable as a director. The court, it's pretty hard to prove some of this stuff. And this is known as the business judgment rule. Liability is not imposed simply for poor business judgment. A perfect example of this is in the Disney company, where the board of directors hired a man named Michael Ovitz. And Michael Ovitz was hired to be the COO, the Chief Operating Officer of Disney. And they gave him a very long contract, and they gave him quite a huge salary. At the time, there was another guy, you guys might remember, Michael Eisner, who was the CEO of Disney for many years. And he was to work in conjunction with Michael Ovitz. My husband was working there at the time. This was about 20 years ago. They were the Michaels, and one was the CEO, one was the COO, and they did not get along. They did not get along at all. So, it got to be a very bad situation, and the board realized they were going to have to fire Michael Ovitz because Michael Eisner had been there for a long time, and it just wasn't working out. And so when they fired him, in his contract that they had entered into, he was, after 14 months of work, he left the company with $140 million. Well, as you can imagine, the shareholders went crazy. Number one, they said $140 million could be pretty nicely divided among us, shareholders. We could have had a dividend out of that. So we think that this was very bad business judgment. First of all, to enter into the contract for $140 million that would last this long. And then secondly, to give him $140 million to not work and to go away, to fire him and send him off with $140 million. So they took him to court. And the state of Florida said, or our court said, that, guess what? We're coming down on the side of the directors. Too bad, Disney. Too bad, shareholders. You elected these directors, and this is, maybe it was a stupid decision to hire him for that long. Maybe it was a stupid decision to fire him and send him on his way with $140 million. But, That's their just in their best judgment. They could find nothing that this was done intentionally to hurt Disney. It was not done it was not reckless. They had put a lot of thought into it. And so the shareholders lost. So the directors win. They were not held personally liable. And now we know that directors can make some pretty big mistakes and not get called out on it. So, a lot of directors got very concerned because they thought, well, I don't know if I want to be a director on a board somewhere because I could get sued by my shareholders, and I can't. It's difficult work, and I don't know when if our stock's going to go up or down. It's not always one single person's fault or even the board's fault. So, to encourage people to be directors, we now have something that is called D&O insurance, and corporations will purchase this and provide it to their boards and to their officers. And that way, if they're ever sued by anyone or the corporation, then this insurance kicks in and covers their costs and covers any let's see, on behalf of the directors and officers, that protects them from liability. It covers the money for the claim in addition to the legal expenses associated with them. The thing it doesn't cover, though, is if the director does perform some willful misconduct or illegal act. That's not covered. All right, so how the heck do you get rid of a director? How do you remove these folks? Well, shareholders are the ones that remove the directors, and they have a chance to do it every year. They can do it with or without cause, and unless the articles of incorporation require that they do have to have cause. But generally, Florida statute, 607.0808 says the shareholders can get rid of them without cause. Sorry, I just hit again. So the shareholders have to vote, and of course, majority rules. It happens at the annual meeting of the shareholders. If proper notice is given, that notice must specify that the removal is on the agenda and it's going to be decided. All right. So in order for a director to leave, either they get voted out by the shareholders at the annual meeting, or the director can actually resign. Chapter 607.0807 says a director can resign at any time by delivering written notice to the board or to the corporation. It's effective upon delivery, and unless the notice says otherwise. They may want to give 2 weeks or whatever. If a vacancy occurs, it may be temporarily filled by a majority of the remaining directors or the shareholders unless the articles provide otherwise. So, because your articles and your bylaws are the law of the corporation, you check there first, and if that doesn't tell you what to do, then you go to the Florida statutes. All right. Now, there is an annual meeting of the board of directors. At that time, they elect the officers or re-elect the officers, as the case may be. They ratify acts of the officers and of the directors for the previous year. They approve the meetings of the last meeting. They approve the minutes of the last meeting. They approve the dividend to be paid to the shareholders for this year. They approve the annual report to be filed with the state of Florida, or whatever state they're in, that they're incorporated in. They review the financial report, and they approve bonuses for the officers and for themselves, for the directors. Then after this meeting, the minutes of that meeting are taken and they are put into the books of the corporation. All right. So this brings us to federal laws concerning the directors. There's 2 federal laws. The 1933 Securities Act. Directors may be held personally liable to purchasers of securities issued by the corporation for any material or misleading statement in the registration statement filed with the SEC. So that basically says that when you are filing your incorporation, your directors, those first folks, if there's any misleading material or any misleading statement, the directors will be personally liable to the purchasers. Then in 2002, we had the Sarbanes-Oxley Act that came around. It was created because we were having tons of corporations that their boards were just doing some hideous criminal things. It was awful. The Sarbanes-Oxley Act primarily affects companies who are traded on a national security exchange or that have at least 500 shareholders and more than $10 million worth of assets. The main provisions of the Sarbanes-Oxley Act are said. It's a very complicated act, but here's the big 3 points. The board for each company must establish an audit committee who will hear complaints about accounting practices and will oversee the CPAs for the company. This was set up because you had companies that were, when the directors realized things were going bad, they would sell their shares and take a huge profit and then cook the books, so to speak, so that it looked like when someone came to take a look at the records and the books, the financial records and books of the corporation, that there was much more money in the corporation than there actually was. Prohibit insider trades during certain time periods of time. Well, insider trading has always been illegal, since 1929. And this crunched the time so that there was a smaller amount of time that insider trading could not occur. Also, it stopped personal loans by executives because the executives were giving loans to these companies, and then the corporations were repaying their executives and their directors, and receiving huge interest on it. They might loan them $1 million and charge them 200% interest, and so all personal loans now have been stopped. All right, so that wraps up our directors. I want to jump in quickly to the corporate officers, and we'll talk about what rights and responsibilities they have. The corporate officers, remember, just like a director, they are an agent. They are considered an agent of the corporation, and so they have a fiduciary duty to the corporation also. The shareholders, not agents. They do not have a fiduciary relationship or a fiduciary duty to the corporation. Officers are agents, and directors are agents. Becoming an officer is as follows. They are elected or appointed by the board of directors or another fellow officer. Sometimes the president of the company can appoint the vice president. An officer may also serve on the board of directors. The required officers are in the, they are in Florida. The statute is 607.08401. Statutory requirements are very minimal. The bylaws will set forth what officers there will be. Okay, so it's in our bylaws. Florida requires at least one officer must be responsible for preparing the minutes of both directors' meetings and shareholders' meetings and for authenticating records of the corporation. That same individual may hold more than one office. So typically, a corporation will have president, vice president, secretary, treasurer, registered agent, and the chief financial officer, which is often the treasurer. But you can have one person holding all of those offices. If you have a very, very small little corporation or perhaps a nonprofit organization, all of those offices can be held by one person. Number 4, the election appointment of officers. The statute, Florida statute, is silent on this. So this is going to be set out in the bylaws, how you appoint or elect your officers. Compensation. Florida statute, again, is silent on this. So this is set out in your bylaws, and generally the board of directors is the one that determines compensation. The meetings of the officers, this again, set out in your bylaws because the statute, Florida statute, is silent. And so the rules regulating the meetings of the officers have to be put in the bylaws. The duties of the officers, they're going to be laid out very specifically in the bylaws. They perform the duties in the bylaws or consistent with the bylaws. Typically, though, you have the title of the officers, the description of their duties, and the method for electing the officers. That is all going to be contained in your bylaws. The officers perform the duties prescribed by the board of directors. All right, number 8, resignation of the officers. We have a Florida statute on that. An officer may resign at any time by giving written notice to the corporation, effective upon delivery unless notice says otherwise. And we also have a Florida statute on removal of officers. The board of directors may remove an officer at any time with or without cause. The personal liability of the officers, Florida statute is silent. Our textbook says that liability of the officers is the same as liability of the directors. So it's going to be that very low standard, but it's a very high low standard, that it has to be egregious, self-serving, there has to be fraud, in order to prove that the officers were acting in bad faith. So we protect our officers because we want them to, if a corporation, we could just be talking about millions and millions of dollars, and it would be impossible to get anyone to agree to be a director or to be an officer on a corporation that has been around for generations and then be liable for something when you're talking about this kind of money. So in order to protect the officers and the board, the directors, we have these rules that generally they have to be doing something with intent. Once you put intent and deceit in it, then it's very easy to catch them. But if they are just doing the best they can and they're just not very good at it and money is lost, then you can't hold them personally liable. All right, I want you to take a look at the very end of the chapter in our textbook, and I want you to read about the role of the paralegal in this part of corporations, because there is so much that is driven by statute, but then so much more is actually driven by the bylaws and the articles of incorporation, and who generally gets tapped for putting those together. That's right, you, the paralegal. So this is just a great chapter. I really encourage you to continue your reading. Continue watching these very exciting lectures that I'm providing for you. And I will talk to you on Tuesday. All right. Have a good rest of the week.